the judges of the court. Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals, held in and for the state of New York, may now draw near, give their attendance, and they will be heard.
New York State Club Association versus the City of New York.
Ready for court, please.
Mr. Comita.
My name is Angelo Comita, Phillips, Nizer, Benjamin, Krim, and Ballin, counsel to the appellant.
Mr. Comita, why isn't this consistent with the state law, merely fleshing it out, so to speak? Where is the inconsistency with the state law?
The inconsistency, Your Honor, is clearly seen in looking at the law as it stands. The executive law, which is the general law of the state with respect to what is the issue here, specially carves out an exemption for clubs which in their nature are distinctly private. Rather than hewing to that line which has been carefully parsed out by this very court as recently as Power Squadrons, in which this court focused upon some of the criteria that would assist in determining whether a club was distinctly private.
That's a key word, though. It focused on some of the criteria.
Yes, some of them.
It wasn't meant to be limiting.
No, Your Honor, we do not say that it is, except every one of the criteria which the court, and of course the other courts which have addressed this, federal and state, have all looked at the life of the club, the practices and the policies of the clubs themselves, rather than the effect of outsiders, if shown, upon club life. What this inconsistent law does is no different than what the town of Red Hook sought to do and what the city of New York, for good reason, sought to do when it attempted to increase the minimum wage from $1 to $1.25. The fact is that if the Constitution of this state, Article 9, means what it says, and the Home Rule law means what it says, and the city, having passed a law which is distinctly different than the executive law of the state of New York, it follows logically, I believe, and I hope and urge that you do too, that if they were the same, or substantially the same, the city would never have done what it did. It preempted an entirely different legislative scheme. No longer is a club permitted to show by its practices and policies that it is private. Once it crosses the threshold of the three prongs which the city of New York, and only the city of New York, would address to its citizenry in 5 boroughs as distinguished from the rest of the state, that private club can no longer look to the criteria which this court advised it could, admittedly not exclusively, but all of which deals with what this court called the essence of a private club: selectivity in membership and a plan and purpose of exclusiveness. Your Honors, if you...
Why cannot it be said, however, that if these certain criteria are met, more than 400 measures, more than 400 members, and so on and so forth, that it's not possible to determine selectivity in these other criteria for measuring distinctly private clubs, because by definition, the membership is too large, the use of the club is too broad to permit it to be a distinctly private club.
Your Honor, I believe that those criteria are designed to vitiate the very definition, that is the city's criteria, vitiate the very definition of a private club. That is to say, the club would never get to prove that it was private in the real sense of exclusivity. And meal service, whether or not others pay for those meals or not has nothing to do with a man or woman's selection of his or her social intimates in the context of a club. There is nothing at all in the three criteria which have anything to do with privacy. Privacy is what the clubs themselves deem to be the most selective of processes, with permanent machinery to determine what those processes are and who they are going to allow in or not. It has absolutely...
Don't you think that there is some relevancy with respect to the term distinctly private? Distinctly private. Some relevancy with respect to the criteria established in the executive order?
Oh, there may, on a factual basis, fact by fact, club by club, and this court has said that it is a question of fact to determine which club is private and which one is not.
But you say that no generic definition of this sort can be set forth?
Absolutely not. And what the city has done is it will make illegal in this city and in Syracuse and in Buffalo and Rochester and White Plains what is clearly legal under the distinctly private exemption of the executive law of this state and under the case law of this state. And I go back beyond power squadrons to Kiwanis of Great Neck, which this court affirmed. What the city has done is it has totally preempted the possibility on a case-by-case basis, club-by-club basis, to determine whether or not a club is distinctly private. You know, no local government can do that. No legislature on a local basis, whether it be the city council or not, can do that. The city of New York has addressed an issue which is very valid. I am not here to dispute the wisdom or the justice of anti-discrimination laws. I am here to parse out the fact that from the very beginning of these laws, with the federal statute under Title II, it has always been clearly exempted. That is, private clubs which were distinctly private. I believe...
You're not talking about preemption here in this sense. You don't argue that.
Preemption, Your Honor, as you will hear it time and again this afternoon from my adversaries, is
Well, not so
not
many times.
I hope not, because it's the biggest red herring in the courtroom this afternoon. We are not talking preemption, we're talking inconsistency. And the inconsistency which Red Hook was brought down on, which the Uniform Firemen's Association was brought down on residency requirements. These cases, which by the way have been meticulously avoided by the city of New York, which has found fit to implement the record before this court by double and triple hearsay vignettes, which are not part of the record of this court, the city has stayed away from distinguishing our inconsistency argument because it can't be walked away from. This law is inconsistent. We are not saying preemption because every large city in this state has an opportunity, indeed an obligation, to implement anti-discrimination statutes, but not to second-guess the state. Because if you make illegal in the rest of the state what is legal in the rest of the state by positing a local ordinance or statute, you are running contrary to the Constitution of this state, and the law is clear. Red Hook, Wholesale Board, and any number of others. If I may, I'd just like to give you a small vignette about how difficult it would be to square this situation with the law.
Now, you just said that your opponent referred to vignettes not in the record.
Yes.
You're not going to do the same thing, are you?
No, I am not. No, Your Honor, absolutely not. I only have 15 minutes.
Mr. Comita, before we get to the vignette,
Yes, Judge.
since you're eschewing any reference to preemption, in order to deal with the inconsistency argument that you've raised, is it possible to reconcile the exemption that you've alluded to by suggesting that that's an authorization for a local option rather than a proscription on local governments to enter this field?
I do not believe, Your Honor, that it can be used as a local option or construed to be a local option, because its thrust is to withdraw a privilege, a right to a large group of citizens, and that is the right to be statutorily exempted from the thrust of anti-discrimination laws which are reserved for public places of public accommodation. I do not believe that any local government would have the option by law to preempt that exemption, and that's precisely what this law does. The courts, I'm sure, will see, this court will see that the private club will never be able to give you any answers, because it will never have an opportunity to go beyond 400 meal service and payment of dues and other for other services. What this means, Your Honor, is that if the state and city allows different standards, there is a curious result. Imagine the same rights complaint, one lodged before the City Commission on Human Rights and the other before the State Commission. The facts presented are the same, but the complainant before the State Commission loses because the club has shown that, the complainant being the city or someone within the city, because the state has been shown by the club that it has the permanent machinery to screen out applicants, and membership is determined by subjective and not objective factors, that it limits its facilities to the use of members and bona fide members. It's controlled by the membership. It's nonprofit, operated solely for the entertainment and the pleasure of the members, and finally, that its publicity is thrust entirely and exclusively to the members. Look, please, and by the way, I have a new case which I'd be happy to give to the clerk for distribution. It's the circuit case, the Third Circuit federal case in Ridgewood, Kiwanis, which has reversed the District Court of New Jersey. In this case, as in many of the cases cited in the brief, you will find that there is one thrust, and that is the pattern of selectivity, the essence of the private club, the fact that our Constitution gives each one of us, on any basis that we choose to have, or no basis at all, even though the worst aspects of some of our societies often show their ugly heads in bigotry and prejudice. But as the Supreme... Yes, Your Honor.
Isn't it significant, though, that the use here is not really the members' use, it's really the trade or business use of non-members that's being promoted?
Your Honor, that third prong is, I believe, while interesting, not determinative of the club life or the selectivity of clubs to admit their members. It is a commercial factor on the part of third parties. That is not to say that the very person paying the check, if indeed that happens a great deal, could be a member of that club. It is club life and how it is practiced and the policies of club life that determines what is public and what is private within that sector of our lives. Just one more minute, Your Honor. Oh, well, I guess not.
No. Thank you very much, Mr. Committee.
There are other arguments, of course, particularly that which Judge Kupferman found very persuasive in terms of equal protection of the law.
And of course, those have been read and will be considered.
Thank you, Your Honor.
So, Malley, what about Mr. Comita's argument with respect to the disparity between the city and state in connection with a violation, where
Well,
if this is affirmed, the city criteria would be fixed and the state subject to more subjective standards?
Well, Your Honor, we feel that the test that has been promulgated under Local Law 63 is quite a well-constructed and well-designed test, certainly.
But
And
certainly not binding outside the city of New York.
Not binding, Your Honor, but it certainly can be applied. In this regard, Mr. Komeda mentioned that there will be a different result if a complaint is brought in the State Division of Human Rights as in one form or the City Commission on Human Rights in another form, that a different result would occur because different tests were being applied. First of all, we think that both tests reach the same result, that applying, and in addition, nothing prevents the State Division of Human Rights applying the law in Rochester from finding that the criteria applied by Local Law 63 can be applied as well under the state law.
But the converse is true as well.
I'm sorry,
They
Your
don't-
Honor, I don't.
The converse is true as well. They don't have to adopt that criteria. They can subject it to subjective scrutiny and tests, and on a fact-finding basis, determine that even though it might be violative of 63, it is not violative of the state law.
I think, though, Your Honor, we submit that applying if the State Division of Human Rights in Rochester finds that a club does fit the criterion under Local Law 63 with knowing that it is not bound by that, it will find that under the criteria that were suggested by this court in power squadrons, that they are essentially measuring the same thing. That is a plan or purpose of exclusiveness, and thus the result will be the same. I just want to mention in this regard, Your Honor, that I don't really understand plaintiffs' inconsistency argument as addressed before this court, because they have conceded, it is agreed between the parties, that the same test, that the law is constitutional and consistent with state law. Both those tests are satisfied, so long as Local Law 63 does not encroach upon federal constitutional rights. That is, Your Honors, although this court has not had the opportunity to address this interpretation of the distinctly private exemption, that is, so long as Local Law 63 does not violate rights of privacy and rights of association, it is consistent with state law because the distinctly private exemption in the State Division of Human Rights law can only be measured by assessing those competing constitutional rights. And that the law does not violate these federal constitutional rights is actually not a difficult question to answer. The rights raised by plaintiffs in this case, as I mentioned, are those of privacy and or intimate association, as recently interpreted by the Supreme Court, and association. We think it is clear, Your Honor, that a club or association that comes within the scope of Local Law 63, that its constitutional rights are not violated. Only family relationships have been protected under the associational intimacy test that was adopted by the Supreme Court in Roberts versus United States JCs. Any club that has over 400 members, that receives revenues from non-members for the furtherance of a non-member's trade or business, and that also serves meals, cannot in any way be said to resemble a family relationship, and so its constitutional rights are not violated, and it has not come within the distinctly private exemption under state law. As I mentioned before, this interpretation of the distinctly private exemption under state law has not been adopted by this court only because it has not been expressly before it. That this is in fact the case is evident from the statutory intent underlying the state public accommodation anti-discrimination law as it was reviewed by this court in power squadrons, when this court said that the public accommodation anti-discrimination law must be given the broadest possible construction.
Your position, I think, would necessarily have to be, if I understand you correctly, that if a club has more than 400 members, and if it provides meal service regularly, even though it has established clearly that it is selective in the admission of members and that it's exclusive within the definition set forth in the Power Squadron case. If it receives payment regularly for dues or meals and meets subdivision C,
Yes.
as a matter of law, it is not exclusive.
Yes, Your Honor, perhaps it might be better
As a
said
matter
as a
of
matter
law,
of fact, because these are factual questions that have been, it's a factual test that has been created by the City Council.
So that it's impossible as a legal matter for any club to meet the exclusivity attributes as set forth in the Power Squadron case and be exclusive if it comes under C.
Well, we would say, Your Honor, that if a club or association satisfies the test under Local Law 63, it would not, neither would it satisfy the exclusivity or the plan or purpose of exclusivity test as it was announced by this court in Power Squadrons. It may well satisfy one or two of the five criteria that was suggested by this court, but this court suggested that it should be a plan or purpose of exclusiveness. Even with a machinery established to screen members, the club may hope to be exclusive in that way, but it's a futile hope because it loses that when it accepts revenues from non-members who it has never screened for membership and who in fact may have been rejected by this club for membership.
It meets the individual tests set forth by counsel in his argument, but failed C. The bottom line is that it's not exclusive.
I don't understand what C is.
If it comes within C of Local Law 63, regardless of whether its promotion is all inwardly directed, whether it has
yes,
all
Your Honor.
sorts of machinery set up so that in admitting members it's exclusive and so on. If it comes under C, it loses.
Well, of course, the club or association must satisfy all three prongs of the local law to come within the law, but yes, it may satisfy 1, 2, 3, or 4 of the criteria suggested by this court, as I said, and it nevertheless could be deemed a non-distinctly private club under the local law. But as I said, if it does satisfy Local Law 63, the club is thereby not existing solely for the benefit of its members, which was one of the criteria suggested by this court in Power Squadrons. It is not supported solely by its members, which is one of the criteria suggested by this court in Power Squadrons. Therefore, it has to fail both tests if it fails one. That is our position,
The
Your Honor.
so-called factual tests, you responded to Judge Hancock by relating this to a factual test. It almost sounds like a per se rule of law.
Well, yes, Your Honor, and we don't think there's anything wrong or that the test set forth by the legislature is a definite test. If you come within the three prongs of the statute, yes, you are not distinctly private within the city human rights law. Your Honor, what we have done is taken practically the most obvious or egregious situation. There would be other
And you have determined, by you I mean the city, as a matter of law, that factual pattern constitutes the opposite of distinctly private.
Yes, Your Honor, and this test was promulgated in accord with this court's decision in Power Squadrons and with the Supreme Court's decision in Roberts versus United States JCs. It is consistent with them. It avoids touching upon clubs that can claim to have rights of intimate association or associational rights, and therefore we do not violate the club members' constitutional rights, and therefore it is not a distinctly private club within the meaning of the state law.
In effect, you said we don't care what you call yourself or how you operate. If you meet these standards, you're a business, not a club. That's what you're saying.
You're closer to a business, certainly, than a relationship that would be entitled to invoke rights, constitutional rights that would disentitle the city or the state from.
You have overstated it. You are not distinctly private.
That's correct, Your Honor. That would be our position.
And would it also be your position that if the same showing were made, it would, as a matter of law, constitute a violation of the state human rights law?
Yes, Your Honor, because we think that if you fail, or should I say come within the three prongs of the law, of the local law, then under state law as well, certainly you would not be distinctly private. We think this test, while we are bound in New York City to apply it, can as well be applied by any city or state commission of human rights within the state of New York. And whether...
You'd have to argue that as a matter of law, it would constitute a violation of the state's human rights law.
If, as a factual matter, a club can be demonstrated, or a club cannot demonstrate, it can be demonstrated that the club satisfies the three prongs, yes, it is not distinctly private under state law.
Thank you very much, Mr. Milley.
Thank you.
Craftmatic Comfort Manufacturing Corp. versus New York State Tax Commission.
Please the court.
Mr. Dow.
In 1976, the legislature exempted medical equipment from...
Excuse me, Mr. Dow, the matter of assessment is not in dispute here, is it?
No, not as far as the issues presented to the State Tax Commission, what the issues were before the State Tax Commission. We're only dealing here with the receipts from the sale of hospital-type beds where...
Oh, I know what the
medical
issue is. I'm
prescriptions-
just concerned with finality here.
I don't think
In
there's
other
any
words,
issue with regard to the
when we
amount.
determine this case, that's the end of it, no matter how we decide it.
That's correct. That's my understanding of the case. Now, when the legislature passed this statute, it gave examples of the type of medical equipment it intended to exempt: dialysis machines, wheelchairs, iron lungs, and things of that sort. These are examples of medical equipment which are used, and they're designed for the one purpose only, for medical treatment.
Hospital beds are an example too, aren't they?
Not as an exemption given by the legislature. By the Tax Commission's regulation, they say hospital beds are exempt under the statute. But we're not dealing with hospital beds. These are not beds sold to hospitals. 75% of these beds are sold to individuals without any medical prescription whatsoever.
But we're not dealing with the 75% either, are we?
No, but we're dealing with the regulation of the Tax Commission. Equipment which is not generally useful in the absence of illness. Here, the petitioner or the respondent has advertised these beds as comfort beds. And certainly, the fact that the beds, 75% of them were not sold under with prescriptions, and the fact that they were sold as comfort beds demonstrates certainly that the beds have a use other than to alleviate or correct physical conditions. Hospital beds sold to hospitals, even though these beds can be used in hospitals, are sold for the purpose of medical care and treatment. Not so these beds. Certainly there's no requirement that a prescription be given to purchase a bed. It certainly does lend some credence to the fact that they're going to be used, but not necessarily going to be used for medical care and treatment. There are other types of equipment, certainly, that you can get a prescription for, as we set forth in our brief. Humidifiers, air conditionings, sunglasses, all these items you can obtain a prescription for them, but it doesn't mean that they're going to be used for medical purposes without the instance of a medical condition. Oxygen tanks certainly has a medical use. They're sold to hospitals for care, and they're sold to individuals for care. But they're also sold primarily for industry, for industrial purposes. Certainly, under this statute as written, if we're going to take a broad interpretation as to what the legislature meant, all these items would be exempt from sales tax because they could have a medical use. We're not dealing here with what could be, but what is. Now, there's no proof.
But when a doctor prescribes something, wouldn't you say that that was specifically for a medical purpose?
It could be, but not necessarily so. As an
Well, I
example,
could have a doctor that says, I think you should have a bed that would make you more comfortable, and yet I can have a doctor that would prescribe it because of an orthopedic reason.
that could also be a friend and say, here, I can help you out with an exemption. Here, I'll give you a prescription, and you can use that.
And you could have a friend that could give you a narcotic drug too, but we're not talking.
Well, but we're not.
We're talking about the legal.
We're not dealing with anything illegal. There's no question of legality as to the issuance of a prescription for sunglasses or a humidifier or something of that sort. We're dealing with a practical administration of the tax. What did the legislature intend to do? I think if the clear reading of the memorandum, the legislative memorandum, shows that this equipment has to be designed for medical purposes primarily. And that's the way the Tax Commission has construed it.
Wasn't this 25% in issue, weren't these beds all medically equipped?
Not as far as we know. Some,
Doesn't your finding in paragraph 4 say that they were medically equipped?
they have Not all are medical equipped with attachments for
Would that
intravenous
make a
feedings and
difference?
something of that sort.
Would that make a difference if they were medically equipped? Would you say these beds should be subject to exemption?
Well, the equipment, the medical equipment attachments to these beds, we say are exempt. And the tax department has, in an advisory opinion, says that these attachments, which are for medical purposes, are exempt, but the beds themselves, no. Because of the fact that it would be impossible for a vendor of these things to determine whether or not these beds are going to be used for medical purposes or just as comfort beds in the way they advertise.
But if they were sold to hospitals, they would be exempt. The very same bed.
The same thing, I think, would apply with the tank of oxygen. I mean, because they're not going to certainly do welding or use making steel with oxygen or something of that sort. Hospitals are in the business of treating patients. They're not going to be using them for the comfort of visitors, or they're not going to use them as our lodging house as a comfort bed.
Isn't there some implication, though, in your list of medical equipment supplies that may be exempt, that where they are in fact used as medical equipment, although not generically so, they may be exempt? For example, you talk about canes, footboards, raised toilet seats, and the like, in your exhibit, page 4041. Canes, some of us use them for medical reasons, others use them for other reasons.
We use them for cosmetic purposes
But
or
if
whatever.
they are prescribed and used as medical equipment, they are, as I understand your regulations, exempt.
Well,
Why not the same for these beds?
Again, under the regulations, what's customarily deemed to be a medical equipment. A cane certainly would be deemed as medical equipment, or a raised toilet seat or something of that sort.
Does the statute add that criterion, primarily and customarily used as medical equipment?
No, but should the tax commission exempt an air conditioner? Just because it can be used for medical equipment, for medical use? I mean, it becomes an impossible situation for the tax commission to administer otherwise.
How about an air purifier for asthmatic?
Again, what was the equipment? I'm sorry, I didn't hear.
Air purifier.
Air purifying, again, the same thing. I mean, we have air purifying to take smoke out of a room.
I said if we had an asthmatic who needed this piece of equipment.
It could be, but again, is this type of air purifier used or designed for medical purposes customarily? And it's certainly in the type of situation that it may not. Perhaps be used for other purposes generally, other than for medical care. There has to be a line somewhere, and certainly it can't be brought, and I think, certainly the appellate division found no fault with the regulation of the tax commission as far as their regulation is concerned. And we submit, there is support in the record for the tax commission's determination.
Thank you very much, Mr. Dow. Mr. Shinofsky? Mr. Shinofsky, why shouldn't since the statute doesn't define medical equipment, why isn't this regulation consistent? And why doesn't it perform the very function that Mr. Dow referred to? Certainly doesn't mean all medical equipment. That was not the intention. That would then include, as is pointed out by Mr. Dow in the dissent, air conditioners, vibrators, air purifiers, everything.
Well, I think that the regulation goes beyond the scope of the statute, Your Honor. The scope of the statute was to be very liberal. In fact, if we refer to Mr. Dow's brief on page 11, where he talks about the legislative memorandum that accompanied it, it says the purpose is to liberalize and clarify the law, thus easing the burden borne by individuals. This law will exempt all medical equipment, supplies, devices, and implements purchased for use by individuals. Now, the regulation went beyond the scope of the statute because it seeks to impose a standard of primarily and customarily used and not useful otherwise.
Regulations can define items within statutes that are vague or uncertain, can they not?
But the language in the statute is not vague and uncertain, Your Honor. When you take a look at the concept of the taxation of New York State and the federal and state of Florida.
Are you saying that the statute should be read, the words medical equipment, to include any equipment used medically or prescribed? Anything prescribed?
That's what the statute says, Your Honor, and that's what the legislative memorandum says.
So that if
And-
anyone could show a prescription for an air conditioner, it would be considered medical equipment?
Under the federal tax laws.
The doctor interprets the statute then rather than the board.
No, I think the doctor interprets the needs of the patient.
Well, as long as he prescribes it, it's tax exempt, so it's up to him what's tax exempt and what's pays taxes.
Well, if you take a look at the federal tax regulations under the IRS code,
I've seen doctors prescribe swimming pools.
and under the IRS code, a certain portion of the cost of that swimming pool is tax deductible. The cost of the swimming pool that exceeds the added value to the real estate is a medical deduction in that year that it's expended. And would also be the same under the New York State tax law.
You're talking about income taxes now, not sales taxes. Are you not?
That's true, but it's the same concept. It's a medical device. This particular bed has been ruled to be a medical device by the Food and Drug Administration. It has, the company that manufactures it is a registered medical device establishment. The doctor's prescriptions refer to it as hospital beds. The Workmen's Compensation Board says it is. Medicare says it is. Various insurance companies look to a doctor's prescription to determine whether or not it's a medical piece of equipment.
It's overwhelmingly advertised as a comfort item, is it not?
No, Your Honor, it is not. In fact, there was a period of time when it was advertised solely as for comfort. That short period of time occurred because the Food and Drug Administration came in and said, gentlemen, you're advertising this bed as a medical device because you say it alleviates certain problems. You have not had it approved as a medical device. Therefore, you can no longer make that advertising. So we stopped making those advertising claims until such point in time as we could get the approval of the Food and Drug Administration. And the Food and Drug Administration does not move very fast. But the advertisements today specifically refer to certain claims that can be made. And even in that, and that's not in the record here, but the Food and Drug Administration admits that the bed is useful for many other purposes, but will not allow us to make those claims to the general public because they prefer claims to be made to the general public for those illnesses for which they allow self-help or self-treatment. Something that they should see a doctor about. They prefer that we didn't advertise the bed could help that. But the bed is useful for hiatal hernia. It's useful for low back pain, edema of the leg, poor circulation in the leg, and everyday aches and pains. True, some people buy these beds for comfort, but that same person would buy a hospital bed. And aside from that, Your Honor, I have to point this out before my time runs out, is that I believe Mr. Dow has unintentionally misled the court because hospital beds sold to hospitals are subject to taxation, sales tax. And his own brief points that out on the bottom of page 11. The sales tax exemption offers relief only to individuals purchased for use in the performance of services for compensation, such as a hospital, will continue to be taxed. So I can't figure out how the Sales Tax Commission came to this position. They list as the very first exemption a hospital bed. But a hospital bed, if purchased by a hospital, is taxable. If it's purchased by an individual, it's not taxable because somebody else may lay down in that bed because it's comfortable. Even a hospital bed can be used by someone else. The consistency escapes me. I just do not know exactly where they're coming from. When the appellate division dealt with this matter, they took a look at the statute and they said, the record, and they said that the record did not support the fact that 75% of the beds were used for comfort purposes. And there is nothing in the record to support that. The most that appears in the record on the top of page 88, and this is in a stipulation of facts agreed to by both parties. It says, Craftmatic markets its beds to consumer groups which include, but are not limited to, individuals for whom the bed is an integral part of their medically necessary therapy. There is nothing in the stipulated statement of
Wasn't there
facts.
some finding that 25% are pursuant to doctor's prescriptions?
That is correct, Your Honor.
So that would mean that 75% logically are not.
It's true that 75% were not purchased pursuant to a doctor's prescription, but that does not mean that 75% were not purchased for medical reasons.
But isn't that some indication that sales tax were paid on that 75%? Which would
Yes, Your Honor, the
indicate-
company's position was that unless they got a prescription from the consumer that said it was recommended by his doctor and prescribed by his doctor, that they would not collect the sales tax because they did not know the purpose for which it was purchased. But the advertising, as was pointed out, consistently makes medical claims for them, for the bed, and people purchase these without it. There are some people who would rather than...
Excuse me, Counselor, do I understand you correctly in that statement that in addition to what Judge Simon said, that the doctor, in some instances, may be described as determining whether the tax is appropriate or not? You're now adding that the company itself, in the other cases, is deciding whether the tax is appropriate or not?
Well, the company had to have some criteria, Your Honor, and it would say to the customer, if you can give us a doctor's prescription, then we will not collect the sales tax. Now, this is no different than in an individual in a store who sells to a contractor. He says, show me your exemption certificate, and I won't charge you the sales tax. I mean, that's the concept and the standard that the law works under, and it works very well. In fact, in the state of Florida, the determining factor is whether or not there is a prescription. Under the IRS code, there are two cases which are referred to in the brief, and both of them deal with a mattress. In one case, there was a prescription for bed boards, and the IRS said, that's a medical expense. You have a doctor's prescription. In another case, where a woman had back surgery and bought an orthopedic mattress, she did so without a prescription.
Are these sales tax cases as well, or income tax?
No, these are income tax cases. Unfortunately, this is a case of first instance.
Unfortunately for whom? Thank you, Mr. Johnson.
Thank you.
People versus Halim Mehmedi.
Ready to call, please.
Good afternoon, Your Honors.
Good afternoon, Mr. Mullen.
O'Brien.
O'Brien, excuse me.
Thank you. It's our position that any error that was...
The reason I'm sorry, I apologize for saying, I was thinking of the case of People versus Mullen. I'm sorry, Mr. O'Brien.
Yeah, thank you. Our position essentially is that any error that was committed here was basically harmless.
That brings me to People versus Mullen.
Yes.
In that case, we talked about substantial compliance being all right in the instance of absence. But here we have a specific statute, and under Caccio, isn't this definite error?
Caccio holds that Caccio involved a situation where a court officer, a clerk, intruded into the jury's deliberations and gave them a pep charge and told them, you've got to come up with a verdict, otherwise this whole case is going to be lost. He interfered with the judicial process, with the whole jury selection, the whole jury process. And the court there held that any unwarranted intrusion into the jury deliberation processes without the presence of attorneys or counsel was totally unwarranted.
Does it make any difference whether it's done by a court attendant or a judge?
Pardon me?
Under the statute? Does it make any difference whether it's done by a court attendant or a judge under the statute?
The facts of this case here are so distinctly different from Caccio that we feel that it calls for harmless error analysis. Here, there was not necessarily an unwarranted intrusion into the jury's deliberation process because both attorneys were present. And that was where the protections that were afforded by that were necessary to the defendant to afford him anything that would be negative to his interests were protected by his counsel. That's where we see the harmlessness coming out of this case. There was nothing there was no adverse effect that he sustained. Granted, the statute says you can't do it, and granted, Caccio says you can't do it. In this instance, it's so small, almost to be insignificant.
But it deals with the organization and the fundamental organization of the court. And wouldn't it under Ahmed, where we said that the defendant must be present when the fundamental operation of court procedures are involved, wouldn't it come within that rule?
he has a fundamental right to be present, and we are not contesting that. We're not contesting that there was an error. The error was here. We're saying that, granted all of that, which happened here, apart from the fact that there was no objection raised or whatnot.
Press that argument,
The objection?
the preservation argument?
Well, apparently, Giaccio would indicate that, on that reasoning, the absence of objection was not a significant factor. But we contend that
There was no objection taken in Ciaccio?
apparently that's what, no, in Giaccio, the facts of Giaccio, there was a vociferous objection.
Well, so why do you say that you don't press the preservation argument?
But because Giaccio, if I can recall the language, said even in the absence of objection, the error is so fundamental that a reversal is warranted.
Well, even if it did
There
say
was
that,
no
that's-
objection. There
that's
wasn't,
certainly
yes.
dictum.
Well, we feel here that this, thank you, Judge, yes. That's exactly, I wouldn't want to be so bold as to say that to this court, but that's our position here. We didn't press the waiver argument as much on the dicta of Giaccio, but this apparently caught the entire process by surprise. Defense counsel, there was no objection whatsoever. There was no dissatisfaction whatsoever. The whole argument at the time was over the wording of the answer that would be given to the court, to the jury. And this seems to be coming up as an afterthought, basically. And in terms of what harm the defendant sustained as a result of this, there is none.
Would there be harm if you've got a statute and you've got a recent case of this court and you've got conceded error? Would there be harm in sending a signal that we're ready to start chipping away at all that solid granite?
That would involve the administrative processes of this court to enforce the court's handling of the trial to require strict and exact compliance. In my opinion, I would feel that in this particular case, to send that kind of a message in a situation where the error is very small would be sending an extremely hyper-technical message to the bench and bar of the state of New York, which seems to be contrary to federal rules, federal judicial decisions, and decisions of many sister states. And granted that the error was there, it's a small error. And I don't think it amounts to a chipping away of the statute.
Well, is it contrary to the statute?
The statute reads that the defendant must be, whenever the
what
jury requests information, that's
what does must
CPL
mean?
301030.
Must is pretty strong, is it not?
Apparently, there's no objection here to the fact that the jury was not called out. That is another part of the must equation here. But here, the emphasis on the second department seems to be that the error lay in not calling out the defendant. And it seems to be that this
But
part
how
here
much
is so
more
small.
explicit should the law be for you to for the judges and the courts to understand that must means must, that the jury and the defendant must be present?
Well,
It must be may, maybe, should be.
well, is an error involving that must, in terms of this case, does that require reversal? And that every time there is a deviation from the mandates of a statute,
And case law.
no matter how severe, even if it's a minor deviation, does that require that we go back and start all over again?
Isn't
That
a
is our
good
position.
signal to send out? Exactly, the right signal to send out.
Then we may get the type of thing which is called malicious obedience. You may have every single mandate of the court, every single statute, every single I dotted and every single T crossed, and the whole system may break down.
Well, that's right.
I believe there's a little breathing room here.
Well, isn't that up to the legislature in the way that they frame this particular statute? In protecting what you conceded to be a fundamental right? I mean, the statute articulates a fundamental right of the defendant to be there at that
But
particular time, does it not?
Not necessarily, Your Honor, because it's a violation of a fundamental right is still subject to harmless error analysis.
But isn't it part of...
Federal courts and our courts, criminals have held this constantly. And here's where we come back to, yes, it was error, but not of such magnitude as to
Isn't
upset
the
the
right to
entire
trial by
process.
jury one of the fundamental rights that you have? And if this is to protect that right, is that harmless? Right to trial by jury, anything that chips away at that, can we say is harmless?
Well, I would say in certain instances where there was no harm committed, that's the essence of harmless error. There was no adverse impact on to the defendant. The jury wasn't even aware of what was happening in this instance. And I don't see it as chipping away at the process. I see this situation as being basically one of a kind. And reversal of this, the second department's reversal of this decision, in our opinion, is sending the wrong message.
Well, it will make sure that it
And
won't
we
be
would
one
like
of
to
a
have it
kind, 'cause
reinstated.
then it'll say it's harmless.
Pardon me?
It wouldn't guarantee that this would be one of a kind if we were to reverse this.
Well, other courts have held that even the fourth department in the case of Johnson, which we cite in our brief, holds that there was an error of an unwarranted communication with the jury that was harmless. So it's not a unique, this situation and the decision under these facts is so unique, almost to the point of being very minute, that the remedy is very drastic. Thank you very much, Officer.
Thank you very much, Mr. Bryant. Mr. Lombardino, you were in the Caccio case, weren't you?
I was, Your Honor, and
So
I
you
must
know
say...
it backward and forward, don't you?
Yes, indeed, and I did not object because in the Ciaccio case, we were not aware of the communication until subsequent to the verdict. So no objection was made, but nevertheless, this court held that in the Ciaccio case, based upon what occurred, it made no difference whether or not objection was made.
But you could have made an objection here.
Pardon me, Your Honor?
You could have made an objection here.
Well, the counsel for the defendant at trial could have, but he didn't. I did not represent the defendant at the trial, but at any rate, Your Honor...
I detected your disclaimer 2 minutes ago.
Somewhat. But at any rate, Judge Wagler, I submit to you that the harm here was very simple. The trial court failed to follow 31030 and failed to follow this court's decision in Ciaccio. And this court said, in effect, that a defendant, if he's not present, that is fatal error. And I think the error here is fatal.
Well, we would have to expand our list of those errors not requiring objection, would we not? This is not currently on that list.
I would agree that the list would have to be expanded. And if this case is reversed by this court, I think what we're doing is telling the courts throughout our state, well, you can go this far, but I don't know how much further you can go. Maybe you can have the reporter go in the next time and read the record to them, even though it be accurate. Maybe you can send the record into the jury and have the jurors read if it's accurate. I think that's a very dangerous
But
situation.
if we don't reverse in this case, then we're saying to all the trial counsel that whenever these things happen, you can just sit there and thank goodness it happened because you have another bite at the apple.
That may be, Your Honor, but we're also telling the courts throughout the state is when a jury wants instructions, you have to take the time out to bring the defendant there, have counsel there, and make the instructions that
Why
way.
couldn't we get the best of both worlds by saying that's so, but in those instances, it has to be preserved by timely objection?
I don't know the answer to that. I just don't know. But I submit here that the case should not be disturbed because of the fact that the trial court failed to follow Ciaccio and 31030, Your Honor, and that's my respectful submission.
Thank you very much,
Thank
Mr.
you.
Lombardino. People versus Elizabeth Hall Wilson.
Ready, the court, please.
Mr. Noonan.
Yes, Your Honor. May it please the court, on behalf of the appellant, the people of the state of New York, I respectfully contend that the order by a trial judge as a condition of probation for a defendant to pay back a person who suffers direct financial harm as a result of the criminal act is consistent with 6510 and 60.27 of the criminal procedure law. The penal law. The appellate division held that the third party, in this case, which is the employer, is not an aggrieved party, is not a victim within the meaning of the statute, and therefore the order by the trial judge was improper. And I would submit to the court that the overall perspective of the sentencing process, and the especially probationary sentencing process, in a climate where probation is achieving a far greater position as our prisons become overfilled, that the one thing the courts have to be certain of is that people do not financially gain by committing crime.
This isn't going to restrict the use of probation, no matter how we decide this case.
It isn't going to.
It's not going to impair the use of probation sentences, no matter how we decide this case.
No.
It doesn't make any difference whether the prisons are crowded or not, does it?
It doesn't, except that if there has to, the more teeth there are in a probationary sentence, and I submit in this case, a very important tooth to put in that probationary sentence is to make somebody pay back what they did. And it should not depend on whether or not a third party who's legally obligated, whether it be an insurance company or anyone else, to pay the loss. That shouldn't take the defendant off the hook. You should be, otherwise, to let this defendant walk away from this case having done $9,200 in damage to another party and having had it paid by her employer, as it was in this case, and not having to be repaid as a condition of probation as a practical matter, is going to mean that the criminal benefits from the crime.
Mr. Noonan, isn't the problem with the statute which speaks expressly of victims?
Except that, yes, it is, Your Honor. But what is a victim? I mean, that is what the issue that's before this court. What is a victim? It's not like the legislature said, we say that a victim is a person who owns the property.
You say someone who suffers a financial loss as a result of the crime is a victim under the statute.
I'm saying that in this case, that is certainly the fact. This case is a little closer than the insurance company I referred to, though, for a very important reason. The reason why the $9,200 loss was suffered by Burns International Security in this case was because of their direct employment relationship with this defendant. They hired her to protect the property that she went out and intentionally did the damage to. And they are in the position of the surety of the honesty that's referred to in, I believe it's the Lynch case, the federal case, of their employee. And if their employee deviates, they pay off the owner of the property, and the fact of that payment should not deprive them of the recourse through the probationary criminal process by getting paid back that $9,200. Now, in this case, perhaps $9,200 would justify, the appellate division concedes that a civil lawsuit is not precluded by the fact that probation doesn't permit this order. And in this case, perhaps the $9,200 is a significant enough sum that the order, that the employer may seek a judgment in a civil court. But the large majority of cases that are impacted by the restitution statute, in my limited experience, involve much smaller dollar amounts, $250 or $500 or $700. And as a practical matter, if that sum of money is in dispute, nobody's going to litigate in a civil court over that amount of money. Furthermore, it's been recognized in a number of cases in the lower courts here and in the United States Supreme Court case, Kelly versus Robinson, which was decided in November, and I forwarded subsequent to my filing of the brief, that the restitution